Hello, and welcome to this video where we will be talking about the concept of privacy in terms of domain 1 of CISSP, risk and security management. It is imperative to know that as a citizen or a consumer of various products, your privacy holds a paramount importance and its protection is even more important. There are several laws and regulations around privacy to protect the individual personal data from being stolen, from being breached. For example, in US, there is a patchwork of laws and frameworks based on each state where an organization may operate and where each state formulated laws derives how the privacy of an individual, be a citizen or a consumer, will be maintained in order to take XYZ services from an organization. EU, on the other hand, has a very wider framework, but it's very pro-privacy. That is why it is absolutely important for an organization to be adherent to the EU policy if they want to operate either in the EU or with the data of EU citizens. There are numerous cases of this EU device laws when not followed by companies who are operating from outside the EU zone and those resulted in the fines and lawsuits against them. In terms of the breach of privacy, the classification of cybercrime may play a very important indicator. For example, a breach can be against an individual via email or spamming, but it can be at large also against the society where an individual is part of and is operating, like forgery or cyber terrorism. It can also play a role in terms of non-tangible assets like property or also against an organization which is, for example, holding your data. So if you go to a supermarket and register for a bonus program, you provide certain details which may become a point of being stolen from that organization. And that is something that an organization has to maintain and protect. In terms of the EU, which is very pro-privacy, the General Data Protection Regulation, which came into existence in 2018, has a much wider scope. It still has certain exceptions, which are restrictions, so to say. For example, the lawful interception, when it is approved by court of law, when it's a matter of national security, military, police, and justice, that this can be subverted in those cases. But for the majority of other cases where there is a business operation which involves holding individuals' data while providing service to them, the GDPR has much more strict implementation rules. Where does it apply? It applies to all sorts of personal data, for example, names, email addresses, also the IP addresses of the website that you may visit, and therefore it has, as I said, has a much wider scope for the protection of personal data. What does GDPR entails? Primarily, it says that that data controllers or the processors or the one which is requiring the individual data to be stored, on whose business requirement the data is stored, as they are called data controllers, and the one which actually process are called data processors. But the data controller sets the requirement. The data controller must be able to provide the free copy of individual data if requested. So for example, if you want to know what is your data currently being held by a service provider who has collected the data from you, you are allowed to have access to that data. You also have right to erasure, that when you no more require the services, that the data that you have given during the usage of services is also erased. Data portability, for example, if you want to change the service operator from A to B, then the data transfer, the portability of the data being transferred from A to B should exist in an electronic format. If in case your data controller got breached and the data is stolen, then you, as the owner of your personal data, should get a notification within 72 hours. And all this is accomplished by making sure that the privacy concepts are not an add-on, but they should remain embedded in the design of the services which an organization is providing. Therefore, it is absolutely necessary that the organization inherits the concept of privacy by design while designing the products and services that it may offer to individual. It is also important that the data protection officers, whose main responsibility is to check that the processing and the monitoring of the data is held well within the confines and the framework of GDPR, should follow the rules of GDPR to the core. So it is important to assign that role in the organization. Now in this snippet you may see an example from 2020, how many companies have had GDPR fines and what kind of fines they had, because if you do not follow one among these various principles that has been stated, then you are eligible for a fine by the authorities. In terms of an international framework for privacy, OECD, the Organization for Economic Cooperation and Development, has a framework where we have 30 members, including US. It's a very old framework. Initial conceptualization happened in 1980s, but it was updated in 2030, so it's much before the actual implementation of GDPR. And this is based on 8 driving principles, which are more or less have a very similar connection to GDPR. And those principles are collection limitation, the data quality, the portability part that we have seen, the purpose specification. Do you really require the data to offer the service? Use limitation, that your data may only be used for the intended purposes for which it is collected. Security safeguard principle, as we have seen privacy by design in GDPR. Openness principle, that the processing is transparent and fair. Individual participation principle, and also accountability principles, that once the data is taken, is processed, that someone remains accountable, like the data protection officer, to make sure that the principles are followed to the core. In the link at the bottom of the screen, you can also look at in depth the further definitions of these 8 principles, but knowing the basics of them should be suffice for your exam. I'll stop here. Thank you very much, and I hope to see you in the next video.